So there's been questions a couple of people raised about the accuracy of evidence in terms of the horizon data. So I thought it'd be interesting to circle back round to David Teale's testimony on the use of computer evidence in the one case of the subpostmaster that he prosecuted. And obviously this follows on from him being unaware of the prosecution code, but we now get a statement that he's also unaware of the use or admissibility of evidence that he put forward as part of the prosecution and had in the file, that he wasn't actually aware of whether it was admissible or not at the time. And we will follow that up with looking at the relevant legislation in Scotland and analysing it and whether the evidence did meet the criteria required for the admissibility of the horizon evidence in this case. Let's jump into the inquiry.
Thirdly, can I ask you about... sorry, that can come down from the screen, thank you. Thirdly, can I ask you about computer evidence in Scotland? What was the law regulating the admissibility of evidence produced by a computer before 2015, the year that you left?
I don't know of any such evidence.
Whoa. I mean, we know that in England and Wales, I don't know whether it applies to Scotland as well, but we know we've got the law which says, computer evidence is infallible. I paraphrase, but something along those lines. Presumably there's something in Scotland. I mean, if there isn't, then that would leave the evidence open to question. So surely that would be the default position without any legislation to the contrary. Let's see if Jason Casey can bring this to his attention. He wasn't aware of the prosecutor code. Maybe he wasn't aware of the legislation regarding computer evidence, which has been critical to so many of these cases.
You don't know of any such law, do you?
No, yes, I beg your pardon.
Is that because you never addressed your mind to it? Or that you know positively that there isn't such a law?
It's because I haven't addressed my mind to it.
Wow. Surely you'd look into that if you're bringing a case based on computer evidence. I mean, some people have pointed out that this is only one case. He's got lots of other cases. So maybe it is an oversight on his part, but it is still necessarily an oversight.
You've told us that in a number of cases you considered files that were submitted by the Post Office as a specialist prosecuting agency.
Yes.
Did a number of those rely on computer evidence?
I can't think of any that did.
What? We know the cases relied on it. Well, we know the Post Office kind of characterised it, if we think of subsequent testimony from Suzanne Winter, that the Post Office seemed to want to classify cases based on their own definition rather than anything that was raised in defence. But it's like there's some kind of willful, we're not going to categorise this as horizon data. Let's see whether there was any horizon data presented in this individual specific case.
Other than this one?
Other than this one.
That in as itself is surely a flaw in the cases then, if the several cases saw horizon data wasn't present in any but this one, because surely that is crucial to proving there's a loss.
What were the other cases about?
Theft of mail.
So would they be raw mail group cases? So to do with the post rather than the Post Office?
I suppose if you make that distinction, yes.
And I think you were going to go on and describe some other species of case.
I can tell you that I can't remember any other case which positively relied on computer evidence. I started in Lochmarrie or the Western Isles in 2000, and I certainly didn't receive any Post Office cases between 2000 and 2008.
You referred in your statement to receiving and considering many reports from the Post Office regarding criminality by their workforce.
Yes.
Which is in paragraph 6. What was the other cases of criminality by the Post Office workforce?
Well, as I say, theft of mail came into it.
And so was that by postmen as opposed to subpostmasters?
Correct. I can't remember any other postmaster that I was involved in the prosecution.
That's an important distinction there, okay? So separating out those cases which are kind of out of scope, I guess, of the Horizon IT inquiry, that's to do with the Royal Mail Group and to do with things which have been brought before Horizon was even a thing. So we are just focusing on this one case then that is identified of a sub-postmaster, which did include Horizon evidence and was related to a sub-postmaster.
Did you, outside of cases involving the prosecution of sub-postmasters, prosecute any other cases that relied on evidence produced by a computer?
I can't think of anything.
And so that would have been from 1982 until 2015, no computer evidence in any of your cases?
Well, all I'm saying is that I can't remember whether there were any or not. I'm not saying that there wasn't.
I mean, that's fair. It's a while ago. I would suspect over such a large time period from 1982 to 2015, there almost certainly was some.
I mean, in that 33-year period, it's likely that there were some, weren't there?
I don't know.
You don't think that there would have been in a 33-year period a case involving computer evidence?
Listen, I can't remember whether there were any cases involving computer evidence or not.
He's getting quite angry, seemingly, at this line of questioning. And like I say, it's understandable that he can't remember. However, I'm presuming that Jason Beer, Casey, is pursuing this line of inquiry because there is some regulations, laws, guidelines, something relating to the use of computer evidence in criminal proceedings that presumably needs to be considered by the Procurator Fiscal.
But in any event, in that 33-year period, you can't recall ever checking what the law was on admissibility of evidence produced by a computer in Scotland?
No.
So we've just had a quick look on the legislation.gov.uk website, which contains all the laws, and it appears that there is indeed a law which has been in place since in Scotland. So this is specific to Scotland, Law Reform Miscellaneous Provisions Scotland Act 1968. So way before, 2 decades before really he was even started his job at the Procurator Fiscal. So over that 33-year period, it was in place all the time. So if we have a look through that, admissibility of statements produced by computers. In any civil proceeding, a statement contained in a document produced by a computer shall, subject to the provisions of Section 15 of the Act, be admissible as evidence of any facts stated therein, of which direct oral evidence would be admissible, if it is shown that the conditions mentioned in subsection 2 of this section are satisfied in relation to the statement and computer in question. So generally admissible subject to the said conditions, which are that the document containing the statement was produced by the computer during the period over which the computer was used regularly to store or process information for the purpose of any activities regularly carried out over the period by any person. That would seem to be satisfied. That over that period there was regularly supplied to the computer in the ordinary course of these activities information of the kind contained in the statement or the kind from which the information so contained is derived. That would appear to apply in this case. That throughout the material part of that period the computer was operating properly, or if not, that any respect in which it was not operating properly or was out of operation during that period was not such as to affect the production of the document or the accuracy of its contents. This section C here would be highly debatable, as they had evidence that actually the computer wasn't operating properly. If you recall, we saw pretty similar wording, if not identical wording, in the witness statement, which Peter Sewell found somewhat contentious but ended up in a template. It was removed. It seemed to appear again in other witness statements. So certainly those witness statements from Fujitsu, they must have been aware of this law to use the wording that was very similar. And it would suggest that in those statements that they felt this was the main contentious point which might not be met, and if such condition wasn't met, would make the Horizon evidence inadmissible in these cases for them to put a statement in refuting that. That's where that wording's come from. And the final one, and that information contained in the statement reproduced or is derived from information supplied by the computer in the ordinary course of those activities, that would be satisfied. So 3 of the 4 conditions certainly satisfied. Condition C of the said condition, all of which have to be satisfied for the computer evidence to be admissible, would appear in this case not to have been satisfied, and based on the evidence we have seen so far, that ought to have been known by the parties bringing the prosecution, namely the post office, through the evidence supplied from Fujitsu, albeit, depending on which case you look at, there is this statement included to basically say, even though there's doubt, we're telling you that there's not any doubt. But when there's evidence to the contrary, how much you can rely on that insertion is, again, debatable. So just thought we'd have a look at that legislation to confirm there is legislation that was in place in Scotland at the time, and indeed for many years before, on the admissibility of statements produced by computers.